Hello, all of you truth-seeking, free-thinking, freedom-loving patriots out there. Welcome back to the Canada Truth Channel, where Canada, the illusion of freedom and system of control is exposed. Today's video is called, Does the Charter of Rights and Freedoms Apply to Common Law? Supreme Court of Canada Case Law Review. A lot of people ask me all the time, why do you do it, man? Why do you study all this case law and all these acts and statutes and regulations and codes and rules of the court and rules of civil procedure? They don't apply to men and women. Why do you study this? And sometimes I'm even berated for trying to show all of you. That's just, all this useless information is just distracting. Stay on purpose, stay on task. And my answer is usually, many people don't know or understand that the deliberate deception, fraud, and tort did not start with the birth certificate scheme. It started all the way back in Canada in 1867 with the British North America Act. It continued on in 1891 with the Judicature Act and the Admiralty Act. It continued on in 1893 through the Statute Law Revision Act, which repealed the enacting clause of the British North America Act, which repealed Section 2, extending the executive authority of Queen Victoria to her heirs and successors. So there's a lot of people out there that say these acts and statutes only apply to the Crown Service Corporation Canada. Well, that's true in a sense. But the entire government justice system has been de facto for a long time, meaning it's not legal, it's not lawful, but it exists. Pierre Trudeau had no lawful authority to even create the Crown Service Corporation Canada through the Canada Act scheme any more than Queen Elizabeth II had a legal, lawful authority to give assent to the creation of the Crown Service Corporation Canada. So the birth certificate is only one piece of the system of control. It's only one piece of the puzzle. And the case law and acts and statutes and regulations and codes and rules that are used against us are tools and weapons developed to suppress the truth, to deny us justice, and to take our freedom. So if you do not understand, if you don't have knowledge and understand the weapons that are being used against you, you have very little chance of defending yourself and almost no chance of defeating those weapons. If you challenge a chess master to a game of chess, knowing only the pawn and the rook, what chance do you have in defeating that chess master? The people that created and perpetuate the system of control are chess masters. So in order to defeat them, we have to know how they think, what their historical decisions have been, what their historical opinions have been, their tactics. For example, the anti-government movement guidebook that they created as basically a shop manual for prosecutors and judges and courts to use against people that were challenging court jurisdiction, that were submitting common law case filings. I'll likely have to do a separate video on that document alone. That's why I study case law, and that's why I show it to all of you, as well as acts, statutes, regulations, and codes. This case law is, again, it's a Supreme Court of Canada case. It's gone all the way up through the courts to the Supreme Court of Canada. And in this particular case, the question is asked, does the Charter apply to common law? And right off the bat, we can see application. Charter of Constitutional Law, Charter of Rights, freedom of expression is the challenge. Interlocutory injunction against secondary picketing. It was challenged, that was against the freedom of expression. Application based on common law rule against inducing breach of contract. Now, a common law rule inducing breach of contract involves a third party intervening outside of two separate parties' contracts. So a third party is influencing or causing one of two parties that have contract to breach that contract. The appellants applied to the British Columbia Labor Relations Board for a declaration earlier on in this case. When the board declined to hear the application for want of jurisdiction, the labor relations of the appellant being within federal jurisdiction, the legality of the appellant's proposed picketing then fell for determination under the common law because the Canada Labor Code was silent on the issue. So the court opinion seems to be, and it's stated later on, that if there's no other law, then the common law applies. And it also kind of implies that they believe that their laws supersede or are above common law. So it's important to understand, again, how they think. All picketing involves some form of expression and enjoys charter protection unless some action on the part of the picketers alters its nature and removes it from charter protection. Charter protection of this freedom does not encompass violence, threats of violence, or other unlawful acts. The picketing at issue, although intended to bring about economic pressure and to induce the common law tort of breach of contract, was protected by the Charter. This is good to keep in mind for those of you at rallies that might be issued fines and tickets. Moving on. The Charter applies to the common law. The language of Section 52(1) of the Constitution Act 1982 clearly includes the common law, and a construction of that section that would exclude the common law from the Charter's application would be wholly unrealistic. There we have a court opinion from the Supreme Court of Canada that the Charter applies to the common law. Excuse me. The Charter does not apply to private litigation completely divorced from any connection with government. Section 32 specifies that the Charter applies to the legislative, executive, and administrative branches of government. Their actions are subject to the Charter, whether invoked in public or private litigation. Although government action is generally dependent on statutory authority, it may rely as well on the common law, as in the case of the prerogative. The prerogative, the right or freedom. The Charter will apply to the common law where the common law is the basis for some government action which is alleged to have infringed a guaranteed right or freedom. It would seem that the Charter would apply to delegated legislation such as regulations, orders in council, municipal bylaws and regulation of other creatures of Parliament and the legislature, corporations. Where, however, a private party sues another relying on the common law, and where no government action is relied upon to support the action, the Charter will not apply. Once again, in their legal system, this is an easy defense. The Charter applies. Every law that is inconsistent with the Charter is of no force or effect. So if they give you a bylaw ticket and it infringes on one of your recognized Charter rights in their legal system, easy out right there. It's quite often very easy to use their laws against them because they are so dishonorable that they don't even follow their own laws. So to expect them to do the right thing and follow our laws, the establishment of a common law court, for example, is not sound strategic thinking. I always like to think, plan for the worst, hope for the best. And by reviewing all of this material, I'm planning for the worst. It would be nice if they would just be honorable and say, okay, we will allow the establishment and be held accountable in a common law court. That would be great. The Charter did not apply to the case at bar. This litigation was between purely two private parties and did not involve any exercise or reliance on governmental action which would invoke the Charter. The application for the injunction was supported in this court solely on the basis of the common law tort of inducing breach of contract. So, quick case history. Once again, the inducing breach of contract, it was involving secondary picket lines, and that was the tort of inducing a breach of contract was decided it was to induce harm. Therefore, it was a tort, a common law tort, because it induced harm, and it was a third party intervening on two other parties' contracts. Per Justice Wilson, on a Section 1 analysis, the purpose and objectives of a common law principle must be ascertained through an objective approach in the same way as the purpose and objectives of an impugned piece of legislation are ascertained. First, does the tort of inducing breach of contract represent a reasonable limit under Section 1? So they're talking a whole lot about common law here in the Supreme Court. In other cases I've reviewed and read, Peter Hogg, the Constitutional Law of Canada, 2nd edition, is cited quite frequently. They really respect what Peter Hogg has to say. In reaching the answer, consideration must be given to the application of the Charter to the common law, and as well as to its application in private litigation. Private litigation, the common law. The Labour Code of British Columbia does not apply. The legality of picketing falls for determination under the common law because the Canada Labour Code is silent on the question. Secondary picketing for the purpose of either the tort of inducing breach of contract or the tort of civil conspiracy, in that predominant purpose of the picketing is to injure the plaintiff rather than dissemination of information and the protection of the defendant's interests. So they're saying the secondary picketing was the tort of inducing breach of contract as well as civil conspiracy, because the purpose of the picket was to induce harm. It wasn't the dissemination of information and protection of the defendant's interests. So the picketing was intended to do harm and also breach the contract from the delivery company to the store it was delivering to. The Court of Appeal dismissed the appeal. The appellant did not seek to dispute the application of the common law by the Chamber's judge. The position advanced by the appellant in the Court of Appeal was that the basis for granting of the injunction, that is, the common law principles adopted and applied by the Chamber's judge, had the effect of infringing the fundamental freedoms of the appellant guaranteed under Section 2 of the Charter, particularly Section 2B, freedom of expression, and Section 2D, freedom of association. So the Chamber's judge decided one way, and the appeal judges are deciding another way. Picketing was to induce a breach of contract. Restraint of such picketing might be a reasonable limit under Section 1. He rejected the application of the tort of civil conspiracy in a labor dispute. So in the laws in BC, the tort of civil conspiracy in labor disputes has been abolished. So you can't charge someone with civil conspiracy in a labor dispute. It should be left to the Chamber's judge to decide whether the picketing would induce a breach of contract. The task of the court in dealing with this case is made difficult by the way it developed in the courts below, as is the case with many court cases. they're appealed all the way up to the Supreme Court sometimes. One judge will say something, or a group of judges will say something, and another group will disagree. So on it goes all the way up to the Supreme Court. And once again, they're agreeing that the anticipated picketing would be tortious and the purpose was to injure the plaintiff. And moving along, the following questions arise. Here we have it. Does the Charter apply to common law? Does the Charter apply to in private litigation? Freedom of expression is not, however, a creature of the Charter. It is one of the fundamental concepts that has formed the basis for the historical development of the political, social, and educational institutions of Western society. Representative democracy, as we know it today, which is in great part the product of free expression and discussion of varying ideas, depends upon its maintenance and protection. John Stuart Mill on liberty and consideration of representative government, Oxford 1946. If all mankind minus one were of one opinion and only one person were of the contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would be justified in silencing mankind. Wow, that's quite profound. And after stating that all silencing of discussion is an assumption of infallibility, yet it is evident in itself, as any amount of argument can make it, that ages are no more infallible than individuals. Every age having held many opinions which subsequent ages have deemed not only false but absurd. And it is certain that many opinions now general will be rejected by future ages, as it is that many once general are rejected by the present. Nothing in the vast literature on this subject reduces the importance of Mill's words. The principal freedom of speech and expression has been firmly accepted as a necessary feature in modern democracy. The courts have recognized this fact. And it goes on, they speak of reduction of the crime of sedition because people have the right, and it's expected, to think differently and speak their differences, promote their differences. And continuing on, this constitutional fact is the political expression of the primary condition of social life. Thought and its communication by language, liberty in this, little less vital to a man's mind and spirit than breathing is to his physical existence. Such an adherence in the individual, it is embodied in the status of citizenship. The Charter has now, in Section 2B, declared freedom of expression to be a fundamental freedom, and any question to its constitutional status have therefore been settled. Period. End of story. That's the way they think. Section 1 of the Charter. Chambers judge, in granting the injunction, did so on the basis that the picketing involved the commission of two common law torts, that of civil conspiracy to injure and that of inducing a breach of contract. So they induced the breach of contract, which was intended and planned. It was a conspiracy to injure, to get their way. I think that the two torts must be treated differently. The tort of conspiracy to injure has not received acceptance in the province. And once again, like I said before, in the province of BC, they, through their labor code, they have said that conspiracy to injure involving disputes will not stand. Without attempting to trace the position of the tort of conspiracy in other provinces, I am satisfied that it warrants this description by Professor Arthur's tort liability for strikes in Canada. The modern tort of conspiracy stands condemned almost universally as a vehicle of judicial anti-unionism. Authors throughout the common law world have denounced it as a weapon wielded with transparent partisanship to counter the aspirations of the trade union movement. So once again, in labor disputes, it's widely accepted that the tort of conspiracy to injure doesn't stand. It should be noted that in British Columbia, the common law tort of conspiracy to injure as employed in labor disputes has been abolished by statute, and it would not be available as a support for the injunction. There you have it. It doesn't say that the tort of conspiracy to injure doesn't apply to others, only in labor disputes. The tort of conspiracy to injure. I wonder who that might apply to. However, since the Canada Labor Code is silent on the question of picketing, the common law applies. In this case, the common law of British Columbia, from which the tort of conspiracy has been expunged in labor disputes. In my view, then the tort of civil conspiracy to injure may not be relied upon to support the injunction, which therefore must find its sole support from the tort of inducing breach of contract. The question then is, can an injunction based on the common law tort of inducing the breach of contract, which has the effect of limiting the charter right to freedom of expression, be sustained as a reasonable limit imposed by law in the particular facts of this case? And he cites other cases, Hunter versus South End Inc., Regina versus Big M Drug Mart, Oaks. Again, there's a lot of cases that are cited over and over. Without attempting to trace the position of the tort of conspiracy in other provinces, I'm satisfied that it warrants this description by Professor Arthur's. Whoops. Sorry about that. While picketing is no doubt a legislative weapon to be employed in a labor dispute by the employees against their employers, it should not be permitted to harm others. Common law. Do no harm. It shows that the application of Section 1 of the Charter to sustain the limitation imposed by the common law would be consistent with legislative policy in British Columbia. So they're saying if a common law or rule infringes on Section 1, then the Charter would apply. Okay, here we go. 52. Everyone is familiar with Section 52. The Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. The English text provides that any law that is inconsistent with the provisions of the Constitution is, to the extent of this inconsistency, of no force or effect. If this language is not broad enough to include the common law, it should be observed as well that the French text adds strong support to this conclusion on its employment of the words, I don't speak French. Emphasis added. To adopt a construction of Section 52(1) which would exclude the Charter from application, the whole body of the common law, which in great part governs the rights and obligations of the individuals in society, it would be wholly unrealistic and contrary to the clear language employed by Section 52(1) of the Act. So, they're once again recognizing common law, which governs the rights and obligations of individuals, but they're claiming the Charter does apply, and it always meant to apply. However, the Charter, once again, ladies and gentlemen, is based on deliberate deception and fraud. It's not a constitution. Never has been, never will be. Does the Charter apply to private litigation? In other words, does the Charter apply to private litigation divorced completely from any connection with government? And this is a subject of controversy in legal circles, and the question has not been dealt with in this court. Moving on, they say, one view of the matter rests on the proposition that the Charter, like most written constitutions, was set up to regulate the relationship between the individual and the government. It was intended to restrain government action and to protect the individual. I will state once again, that is the purpose of a charter, a constitution. However, our Charter of Rights and Freedoms never has been and never will be a constitution. It is the corporate charter for the Crown Service Corporation of Canada, Inc. And not only that, it perpetuates the deliberate deception, fraud, and tort that Canada confederated, and Canada has a legal and lawful constitution. The rights guaranteed by the Charter take effect only as restrictions on the power of government over the persons entitled to the rights. The Charter regulates the relations between government and private persons. Now, the private persons they're referring to are the artificial persons not acting as agents of the government. But this statement does not regulate the actions of a man or a woman. Our actions are regulated by the duty to do no harm. In cases where private action results in a restriction of a civil liberty, there may be a remedy for the aggrieved person under a human rights code, under labor law, family law, tort law, contract law, or property law, or under some other branch of the law governing relations between private persons. But there will be no breach of the Charter. And Professor Swinton states, One should also keep in mind the concerns of the federal and provincial governments in drafting and agreeing to the charter. Their focus was its effect on their own government operations. Let me say that again. One should also keep in mind the concerns of the federal and provincial governments in drafting and agreeing to the charter. Their focus was its effect on their own governmental operations. And of course it was. It was written by the government for the government. It was written by the de facto government to perpetuate the illusion of freedom in a system of control, to perpetuate the illusion that Canada has a constitution. This is quite funny. The override section, section 33, allowing the legislatures to enact laws infringing the charter, also indicates that the governments were concerned about bounds on legislative action. Well, of course they were. Does the U.S. Constitution have a section 33, a notwithstanding clause that says any of the fundamental freedoms or legal rights guaranteed to you can be taken away by legislative action? The automatic response to a suggestion that the charter can apply to private activity without connection to the government will be that the Charter of Rights is designed to bind government, not private actors. That is the nature of a constitutional document. And once again, yes, that is the absolute nature of a constitutional document. But the Charter of Rights and Freedoms is not a constitutional document. And changing the name of the British North America Act 1867 to Constitution Act 1867 doesn't make that a constitution either. Once again, it's all based on deliberate deception and fraud. All of it. So the birth certificate is not our only concern here. Anne McKellen and Bruce P. Ellman, to whom does the charter apply? Some recent cases on section 32, and that book reviews case law. In conclusion, it is suggested that a better view is that the charter applies only to government action. In cases involving arrests, detentions, searches, and the like, to apply the charter to purely private action would tantamount to setting up an alternative tort system. That sounds like reverting to common law, doesn't it? So if harm was proven in cases involving arrests, detentions, searches, and all the like, between private actions between men and women, common law. But they're saying we would have to set up a completely alternative tort system. The action will also be unconstitutional to the extent that if it relies for authority or justification on a rule of the common law which constitutes or creates an infringement of a charter right or freedom. In this way, the charter will apply to the common law, whether in public or private litigation. It will apply to the common law, however, only insofar as the common law is the basis of some governmental action which is alleged infringes a guaranteed right or freedom. We have concluded that the charter applies to the common law, but not between private parties. The problem here is that an action between private parties in which the appellant resists the common law claim of the respondent on the basis of a charter infringement. The argument is made that the common law, which itself, subject to the charter, creates the tort of civil conspiracy and that of inducing a breach of contract. And here they're citing Professor Hogg, who said, the charter will apply to any rule of the common law that is specifically authorizes or directs an abridgment of a guaranteed right. While in common law, the duty is to do no harm. So does do no harm not include on infringing on someone else's rights? Once again, Professor Hogg. In a sense, the common law authorizes any private action that is not prohibited by a positive rule of law. If the charter applied to the common law in that attenuated sense, it would apply to all private activity. But it seems more reasonable to say that the common law offends the charter only when it crystallizes into a rule that can be enforced by the courts. Then, if an enforcement order would infringe on a charter right, the charter will apply to preclude the order and by necessary implication to modify the common law rule. And I would argue against Professor Hogg's opinion that the common law authorizes any private action that does not cause harm. The charter would apply to private person exercising the power of arrest that is granted to anyone by the criminal code. So here we are again. Once again, this is the section 32. Who does the charter apply to? He is referring to provisions in the criminal code that says anyone that witnesses a crime can make a citizen's arrest. Now, once again, the private person they are referring to here is the artificial person who is not acting as an agent of the government. That's what they're saying here. This demonstrates when the artificial person or corporation is implementing or acting under an act, statute, regulation, or code, blah, 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 is acting as a agent to the government. The charter applies, and therefore, by default, all the other laws. So, even if you're the artificial person who we're deceived into believing is us, is milling around out in society and is not acting as an agent of the government, is interacting with another private person, the charter doesn't apply. And by default, the charter is the supreme law of Canada, so other laws don't apply either. And that's been stated in other court decisions as well. All action taken in exercise of a statutory power is covered by the Charter by virtue of the references to Parliament and Legislature in Section 32. The Charter would apply to the action of a commercial corporation that was an agent of the Crown by virtue of reference to government in Section 32. So, of course, all statutory power is covered by the Charter because statutory power is power over artificial persons and corporations, not men and women. It would also seem that the Charter would apply to many forms of delegated legislation, regulations, orders in council, possibly municipal bylaws and regulations of other creatures of parliament and legislatures. It is not suggested this list is exhaustive. But once again, if we look at mask bylaws, the municipality was created through statute. The municipality implements government policy and procedure. Therefore, the charter applies. So when they come at you with their mask tickets, once again, without going into the I'm a human being, not a artificial person or corporation, with the average police officer, you can refer to the charter. However, a private party A sues private party B, relying on common law, and where no act of government is relied upon to support the action, the charter will not apply. Of course not. And once again, the common law tort of inducing breach of contract. Private party A has a contract with private party B. Private party C does something that causes the breach of contract. That is a distinct issue from the question whether the judiciary ought to apply and develop principles of the common law in a manner consistent with the fundamental values enshrined in the Constitution. The answer to this question must be in the affirmative. In this sense, then the charter is far from irrelevant to private litigants whose disputes fall to be decided at common law. In the case at bar, however, we have no offending statute. We have a rule of common law which renders secondary picketing tortious and subject to injunctive restraint on the basis that it induces a breach of contract. While we have found the charter applies to the common law, we do not have in this litigation between purely private parties an exercise or reliance on governmental action which would invoke the charter. The search under Section 1 is, I believe, for the appropriate test to apply when weighing a principle of the common law against a fundamental freedom protected by the charter. Fundamental freedoms and fundamental rights are protected by common law. No need to have them protected by the fraudulent charter. It seems to me that the same objective approach must be taken when weighing a principle of common law against a fundamental freedom. Once again, in common law, you can do what you like as long as you do not cause harm. Pretty simple. But there you have it, ladies and gentlemen. So to any of those dissenters out there that's saying, oh, common law is a myth, it's like the unicorn, it's not recognized in law, yada, yada, yada. Well, here you have a Supreme Court case review that says otherwise. So that being said, if you like the content and all of that good stuff, please give a like and maybe subscribe. Once again, I will leave the link to this particular case file in the description. I encourage everyone to, as always, do your own research, develop your own level of knowledge and understanding, and then pass it forward. Thanks for watching, everyone.